All right, so let's take a look. Let's transition to the next topic, and that is to do with the divide that we see between the National Assembly and the Senate. Of course, last week we saw the governors marching all the way to the Supreme Court. Then we saw the senators doing a similar procession. Senator Ledama Olekina was there. Were you there?
Yes, I came later on.
Is it that you don't believe in it? Let's just take a look at what the Chief Justice David Maraga had to say alongside the Governor of Murang'a, Mwangi wa Iria.
Bearing in mind that these are institutions of states that are working together all the time, it would be most advisable if you could resolve this matter amicably so that we don't have to make orders from the court.
So we have not digested that part, but I mean that was a suggestion, and he said you can take it all or leave it. So we are at that point. We'll consult within ourselves.
Okay, all right. So, conflict between the governors and Parliament and the National Executive, and at the same time a conflict between the Senate and the National Assembly. The Chief Justice is saying that it would be better for teams to consult and agree amongst themselves. I mean, Senator Kang'ata, so the matter is in court later this week. I understand that the governors have until tomorrow to serve the parties to the case. Where are we going with this?
Yes, it is true. There is a law which is called Intergovernmental Relations Act, and it provides that before any government entity takes another government entity to court, they need to exhaust what we call alternative dispute resolution mechanisms. I am not so sure whether these mechanisms were exhausted, which calls for mediation between the parties. So therefore, for me, it is true that's an issue probably the responding party may raise and say, no, we ought to have taken a better route. Be that as it may, the reason why Senate went to court is because there were strong grounds supporting their case, which is failure by the National Assembly to adhere to Article 110, Sub-Article 3 and Sub-Article 4 in passage of several pieces of legislations. We have 15 pieces of legislations. There are 15, but it's only some of them are what we call omnibus legislation. That is, for instance, we have the Statute Law Miscellaneous Amendment of 2017, another one, Statute Law Miscellaneous Amendment of 2018. We also have what we call Equalization Fund Appropriation Bill of 2018. We have what I would call the National Youth Service Bill. Several pieces of legislations. You find, for instance, some of them provide for matters that have been devolved. For example, housing. There was an amendment to the Stamp Duty Act removing stamp duty for first-time homeowners, whereas you know very well housing is a devolved entity. There was an amendment to what we call the SACCO Societies Act, where they were touching on issues concerning SACCOs. You know, SACCOs are cooperatives. Again, cooperatives is an area that falls under the county, so therefore a reference to the Senate was supposed to have
So, Senator Ledama, what happens to counties moving forward? So what happens to them given the fact that they cannot even go ahead and create their budget for the next financial year? Projects will be stalled. Where do we go on even as this drama continues?
First of all, let me just correct my colleague and also maybe just weigh in a little bit on what the Chief Justice was saying. Yes, the Constitution of Kenya envisioned a position where justice can come in all different forms, ADR under Article 159, which my colleague just reminded me. But in this case of division of revenue, we have exhausted the ADR mechanism. And I say so because we had the mediation committee when the two houses were not able to agree on which form or how much money should go into the counties. I was a member of the Division of Revenue Mediation Committee, and we sat there for days with both the members of the National Assembly, and we could not be able to agree. This is a task which is in our domain as a Senate and also as a National Assembly. It is not something which the governors can come in and say, we want to join in terms of mediation. So I don't know where the Chief Justice wants to take us in that, because even what the governors are seeking is an advisory. And you remember in the last Parliament, the Supreme Court already pronounced itself on the matters of the Senate and its powers.
So
issue number 2 that you're raising, you're asking what next?
Yes.
This is a matter that does not only affect counties. It is a matter that affects the entire nation. We are actually moving to a government shutdown because the president himself cannot be able to give operation into the bill that he signed into law, which is the Appropriations Act. Because there's no way, what money are you going to be dividing to the ministries? You know, you've not been given any money yet. And this is the reason why you saw...
But they can access 50%.
No, I'll get to that point.
Budget.
I'll get to that point. The issue is this, the money that the national government has, it is the money which is divided by the division of revenue bill, where the county government gets their money and the national government gets its money, its share of money. So if you're going to say, okay, we're going to use our own money, we're going to appropriate our own money, what are you appropriating in the first place? So the best thing for us to do is this. We in the Senate have gone to court to be able to challenge legislations that were passed without considering, without the Senate view being considered. You know, those are very serious.
But let me just ask, Senator, when these bills were being considered at the National Assembly, was Senator aware?
I'll put it this way. The article, I think, the same, I can't remember the article, my brother will remind me, requires, Article 110, actually,
on
Subsection 3 on concurrence, requires that any bill which is being discussed by either house, mostly from the National Assembly that affect counties, the two speakers must be able to sit and talk and say...
So that's what I'm asking.
No, that never happened.
If that didn't happen,
that did not
was
happen.
the Senate aware that National Assembly is considering a certain bill that might be touching on counties in its exclusion?
Once a bill has already been read the second time, and it has never been brought to our house, and then after that, third time, and it's sent to the president for it to be a set into law, then we lose any say in that bill. You know? So in the instance, what the Constitution contemplated a situation whereby the two speakers discuss and say, does this bill affect county? You know, in all bills that are being introduced in either house. So it's not that you choose. You say, I'm the Speaker of the National Assembly, so I am the big boss. I can be able to do what? To determine which bill affect the counties and which does not affect the counties.
So, Senator, if you don't get the monies that you've requested for, what next?
To get into your question, let me put it this way. This is not a problem that will affect only the county governments. The county government shall continue accessing up to 50% of their money on account, vote on account. But this should not be the solution. The solution should be, we should actually now have the court help us in determining whether we are right or the National Assembly, which has become an extension of the executive, is right.
Okay, all right, we need to wind up, but Mheshimiwa Oluoch, you sit at the National Assembly and the Senate has published its bill, its version of the Division of Revenue Bill at 335 billion shillings. I don't know whether you still consider it as a money bill, in which case it should originate at the National Assembly. Your house has also, or I believe will, or has already published a bill of 316 billion shillings to the counties. So, I mean, so where do you go? Which bill gets considered by Parliament?
Okay, first of all, the Senate has gone to the court, and I think the question that I hope one of the questions that will arise, I'll address the issue about the ADR by the Chief Justice. But I hope this question arises. You know, when you go to court, one of the things you should do, if you're going to seek justice and to seek equity, is that you must go with clean hands. There are claims about National Assembly breaching provisions of the Constitution about joint resolution and then bills that concern county that should go to the county. But Article 109.5 specifically says what cannot be originated from the Senate. And it says that any member may bring a bill, but a bill concerning money or a money bill can only be originated in the National Assembly. It's very clear under Article 109. So I don't know to what effect the Senate or to what end the Senate is attempting or has attempted to originate a money bill, and at the same time is in the court trying to say that the National Assembly has breached. So obviously, I think that is a total breach of the Constitution itself. It cannot go anywhere, as far as I'm concerned. It cannot go anywhere. I wanted to...
no, you may not. Fred, in closing, in 30 seconds. So, after observing all this division, governors versus everyone, and the senators versus the National Assembly, and what they have now, two bills of the same thing, so where do we go out of here? Does Punguza Mizigo help us deal with this?
I think the constitutional provisions are explicit. And if you go from Article 109 to Article 111 that are explicit. And I think the members of parliament tried to follow that and they failed and they ended up at the nation. But remember, the national government and the county government are also distinct and interdependent. And also, they advise that they should conduct their relations on the basis of cooperation and consultation. Okay. So that consultation should have happened. But the advisory that the senators are trying to get from the Supreme Court,
not the governors.
The governors, sorry. Right. The governors are getting from the Supreme Court should give way. It is not going to be a determination, but it should give a clear way of what should happen next. But going back to Punguza Mizigo, look at the proposal that we are putting on saving this situation. The senators should now be able to look at the legislation that's coming from the National Assembly. We must have a reconciled parliamentary structure so that they look at those laws that are coming from the National Assembly.
I see Senator Ledama smiling.
Just 1 minute. If these laws are not pro the people, if these laws are not constitutional, then they can send them back. Lastly, the Senate. Anthony has always argued, and I don't know why he didn't say this here before, that the senators are participants of lawmaking, and the National Assembly members are enactors. But if you look, I'm also a student of Dr. Okot, who's a lawyer, and he says, in law, you must interpret in plain English. Enacting and participating are the same thing.
No.
Okay, all right.
That is not true.
We will leave it there. I don't know whether making the Senate the upper house will just be redefining the supremacy battle, because obviously you haven't really reviewed the mandate of the National Assembly in your bill. So thank you so much for taking part in this, and of course sending us your feedback on Twitter at Citizen TV Kenya, the hashtag being Daybreak. We'll be reviewing, or we'll be looking at some of those tweets later on the show. But now we take a short break. When we return, we have Sporty Monday with Willis Raburu and his panelists to talk about matters football, and of course
yes, plus that last game in AFCON, Senegal versus Algeria. I'm sure they'll be touching on that. Senator is already clicking.
He's so annoyed.
We'll be right back.
He said he does not understand. He does not understand football.
The winners lost.